everyone, I'm outside. I'm about to talk about pixels as usual in my little sweater looking like Mr. Rogers. Today's show is brought to you by the letters G, D, P, R, or just privacy in general. So let's get right to it. Um, I wanted to bring to your attention this article because I think that we don't understand the impact of what is happening right here. So I saw this um, earlier this week. District court rulings could signal expansion of the California consumer privacy right of action. Now, this has to deal with pixels. Shout out to all my ad ops people out there. We've been struggling for years trying to tell y'all to pay attention to what we're doing because now apparently you can get a case if you don't get this. So let's begin. So it says that in two recent rulings, judges in uh, the U.S. Northern District of California have proposed class actions under the Consumer Privacy Act. And the interesting part about this whole thing is that they're letting it go without a breach. So, in this particular situation, they're like, hey, as long as the data or the PII was exposed to any third parties, we're going to count it. We're going to let this class action roll. And I'm going to read some specifics before I tell you why y'all need to listen to ad ops people. So, the case is Shaw versus Capital One Financial Corp. And Capital One makes a motion to dismiss the plaintiff's CCPA claims, right? So the plaintiff right here alleged that Capital One violated the CCPA by allowing third parties such as Google, Facebook, uh, Metapixel, and Microsoft to embed trackers in the website that transmitted personal information about the plaintiffs to these third parties. Let me skip down. The court rejected this argument, holding that the plaintiffs need not allege breach, interpreting unauthorized access and exfiltration, theft, or disclosure of personal information broadly to mean disclosure of personal information to third parties without consent. Now, I got through all the legal jargon to get to this point. You need to watch this case closely because, as I'm interpreting it, they're saying that because the PII and the pixels basically fired on the same page, that they exposed the third party, they exposed the plaintiff's information to Google, Facebook, pic, you know, sorry, Meta, and Microsoft. So I can't say that I know all the details of this case, but what I can say is ad ops people, y'all need to learn how to express yourselves because it looks like we're going to be very important going into the future to testify in some of these cases. And the reason why I say that is that particular part about saying, you know, the court rejected the holding because it's still unauthorized access because the pixels were there isn't really technically true in our world. All right? In our world, pixels and PII might be on the same page, but you have to perform a specific technical edit to the code or to the pixels in order for the pixels to actually see the PII, right? So a page might load with my full government, my birthday, my social even, and a pixel might fire on the page. But unless one of us ad ops people edit the pixel to absorb the PII in the form of what we call maybe extended data. That's an old school term. I don't know what they call it new in the new age. But unless we make the pixel or prepare the pixel to absorb the data, they're not gonna see it. I mean, maybe further down in the case, they might talk to some people of expertise, or maybe in California, it really doesn't matter. But what I'm saying is this: if you can't even be on the same page as PII and not setting up the pixel to collect it, then a lot of your clients are not going to be able to track maybe funnel data, right? So let me give you an example. Let's say you have a credit card application, and the first page is the page that you fill out all the information. The second page is where the client verifies the information in their backend systems. And the third page is the confirmation that says, hey, everything checks out. You might have yourself a credit card. The first page is the page that collects a lot of the PII, and that is usually a key page in the funnel to show that a person, a potential customer, has started your application for your credit card, and they may go down the process. If even loading on that same page is a problem, advertisers may not be able to sort of push people down funnels. Now, I use credit cards as an example, and maybe that might not have be something that we can do now, but I think that we need to be able to express ourselves going into the future, because we are the experts in this area that know that specific nuance. We know the nuance that you need to prepare those codes from those third parties to collect the data. And just because they're on the same page doesn't mean that they're absolutely collecting. Again, I don't know the details. Maybe the ad ops person did set it up to collect, maybe they didn't. But watch this case. It's important. Express yourself, because they're gonna need to hear from us. All right, I'm signing out. It's mad hot out here. I gotta go. But I'll put the article in the description. I'll check it out. Tell me what you think.